Now, if the EEOC had determined there was reasonable cause that discrimination occurred with Kara, there would be 3 options available to the parties involved: mediation, settlement, and conciliation. Mediation is voluntary, and it's the first option pursued if both parties agree to participate, and it's an alternative to litigation. And it can cost a lot less than going to court. The EEOC will work to set up an agreement with the employer or offer both parties voluntary mediation. Mediation is conducted by a neutral third party who, to resolve misunderstandings, finds areas of agreement and develop a voluntary and negotiated resolution to the discrimination charge. Mediation can be conducted without lawyers present unless your company or the employee wants one there. In any case, you should consult with your lawyer before beginning the mediation. Agreements reached by mediation don't constitute an admission by the employer of wrongdoing. If an agreement is reached in mediation, you will not go to court, and this saves a lot of time and money. If an agreement can't be reached, the EEOC will take it to court against the employer or provide the charging party with a right to sue notice, which means the charging party has 90 days to file a lawsuit on their own behalf.
The second option is settlement. The goal of settlement is to reach an agreement that is satisfactory to all parties. With that in mind, let's see if you can figure these out. True or false? Voluntary settlement can be done at any time in the process with no admission of liability. Do you think that's true or false? Yep, it's true. Settlement agreements are not enforceable unless mediation occurs as well. True or false? False. Settlement agreements are enforceable. If all parties reach a voluntary settlement, the charges are filed away for 1 year and then reviewed. True or false? False. The charges are dismissed.
And the third option is conciliation. Conciliation is also a voluntary process that involves negotiation, offers, and counteroffers. Conciliation is a more informal route and the final opportunity to resolve the charge before the EEOC brings the matter to litigation or issues a right to sue letter to the complainant. Conciliation happens after an official finding of reasonable cause determines that discrimination has occurred. It involves discussion between both parties to find an appropriate remedy for the discrimination that occurred. In a very small number of cases, the EEOC will bring the matter to litigation. Usually, the complainant proceeds using the right to sue letter, and employers may choose to hold conciliation discussions in order to remove any uncertainty about cost and time of litigation.
Know the resolution or remedies the EEOC may seek for the individual who filed the charge of discrimination. The main goal is to make the person whole again. They may do this through employee reimbursement for things like lost wages if not given a promotion, get an employee hired if they were discriminated against and not hired, reimbursements for attorney's fees, witness fees, and any court costs incurred. Compensation and punitive damages are possible if the discrimination was intentional.